Happy Friday, everyone. My name is Blake Hampton. I'm the president of the Lee County Bar for 2021, and we are at our April 16th Baker Act luncheon. And at this time, I would like to welcome Judge McHugh to the stage to do the Pledge of Allegiance and invocation.
All right, if everyone would stand for the pledge first. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, and now for the invocation. All right. Yeah, you can go ahead and be seated for the invocation. All right. All right, you bow your head. We are thankful for this day that you have given us, for its blessings, its opportunities, its challenges. May we appreciate and use each day that comes to us. We pray for strength and guidance for each day as it comes, for each day's duties, for each day's problems. May we be challenged to give our best always, and may we be assured your presence with us. Amen.
Stay up here?
Yeah, I'll just take it.
All right. Judge McHugh's coming right back. I'd like to start next with acknowledging the dignitaries in attendance with Chief Judge McHugh. And the Honorable Kimberly Boselli. The Honorable Devin George. Honorable Robert Branning. The Honorable Josephine Gagliardi. And on Zoom, Honorable Shannon McPhee. Right, so next up, we are going to swear, and our Judge McHugh is going to swear in our two new judicial liaisons that join our LCBA board as non-voting members. So we're very excited. This will be the first time that this has ever happened. So again, I'm going to welcome Judge McHugh to the stage.
Thank you. All right, and a couple things to say about these positions before I do swear in Judge George and Judge Brandon. When the Lee County Bar came to me about these positions, I actually was pretty excited about it. Having gone through this last 13 months with COVID, I've really learned the importance of communication. As we've gone through this, I've continued to have stakeholder meetings so that we can keep 5 counties, 5 clerks, administrative judges, the private bar, et cetera, informed as much as possible. And we really have had very few problems, all things considered, other than obviously the huge problem that we were dealing with as we went forward. And communication is so important. And so when I was approached about these positions, I thought it was a great idea. And so I started to think about who would be, great people to be communicators that are easy to talk to, that are more than willing to keep an open mind and think about problems and situations and way we can improve our processes and deal with problems. And so hopefully these are people that you can reach out to as the bar for suggestions, issues that you might have, but maybe also every once in a while a compliment, and say how things actually are going well in a courtroom so that maybe other judges can emulate that. And so Judge George was telling me someone from the bar said, we're really glad we're going to have you in our meetings because this will bring a real, more serious, somber attitude, towards the meetings. And if I knew that that's what we were going for, maybe I would have thought a little bit more about the selections, because I actually wanted people that you could approach and talk to and that you weren't concerned with expressing problems. And so I'm very excited for Judge George, who's going to be our county court liaison, and Judge Brandon, who's going to be our circuit court liaison. I think they are very approachable. They both have been judges now, I think 7 and 5 years. And so they've been judges for a while, but they're also not too far out of practice. And so hopefully, they will have a good perspective. And so if you'd like to come up for me to swear you in at this point. I do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and of the state of Florida, that I am duly qualified to hold office under the Constitution of the state, and that I will well and faithfully perform the duties of my office on which I am now about to. So help me God. Thank you. And hold on one second. This makes it official. Let's get these very official badges which say George Honorable Robert Brannon, Judicial Liaison. So. All right, and I also want people to know, if you do have issues or concerns as Chief Judge, I'm also always more than willing to hear your issues and concerns. Feel free to reach out to my office as well, and I will try and solve your problem, or if it's particularly difficult or labor-intensive, I will turn it over to Judge George and Judge Brandon. But thank you for having me.
Thank you, Judge. Grab my secret water. Thank you, Judge McHugh, and welcome to the board, Judge Branning and Judge George. All right, next up, we are going to recognize our annual sponsors, because without our sponsors, none of this would be possible. Start with Copy Lady. Copy Lady here? No? No? That's perfect attendance for like the last 5 years is gone. Anyways, Kelleher Law. U.S. Legal Support, Edison National Bank, Fort Myers Court Reporting, Boyle, Leonard and Anderson, Sanibel Captiva Community Bank, the Vistas at Eastwood, Associates and Bruce L. Shiner, Boy, Agnew, Potanovic, and Miller, Del Lago Law, Hampton Law, Henderson, Franklin, Starnes, and Holt, John Webb Legal Group, Law Offices of Dennis Webb, Law Offices of Michael Rahab. Thank you for the dinner bell as well. Park Royal Behavioral Health Services, Aloya, Roland, Lubell and Morgan, Conrick PR Marketing, and Sexto Productions. Now it's time to welcome, so Park Royal is also our lunch sponsor today, tethered perfectly with the Baker Act Luncheon, and they are going to come up and say a few words. So we appreciate them very much for sponsoring this luncheon.
Hello, I want to thank everybody so much for coming. We're really excited to have this panel here today. And I just want to tell you a little bit about Park Royal Behavioral Services. We are the only freestanding private behavioral health hospital in Fort Myers, and we have 114 beds, which consist of 5 specialty units. We have a geriatric unit for seniors who are struggling with confusion, possibly dementia with behaviors and cognitive decline. We have an all-women's unit where we address women's issues, and we have all women staff. We have a co-occurring unit where we address substance use and mental health disorder, and we also provide detox services. And then we have an acute unit for your aggressive and psychotic patients, and subacute for not as aggressive and psychotic patients. We also have outpatient, intensive outpatient, which is 5 days a week, 3 groups per day, and partial hospitalization programming, which is 5 days a week, 5 groups per day, and medication management. And then we also have ECT, which is electroconvulsive therapy, and studies prove that it is very effective for those with treatment-resistant depression and bipolar. So with that being said, I will introduce the moderator, Nicole Calderon. She is the Public Defender and Mental Health Coordinator for the 20th Judicial Circuit. She's a criminal trial attorney with an emphasis on mental health litigation. After being on a trial track for a few years, Nicole became extremely passionate about criminal competency and the incarceration of mentally ill individuals. Her focus area is on competence to proceed, Baker Acts, and mental health mitigation. Nicole also has a master's degree in criminology from University of Cincinnati and a master's degree in social work from Florida State University. So thank you so much.
Thank you for that introduction. Thank you so much. Thank you everybody for attending today to discuss this very important topic that's affecting not only our state but also our country. I'd like to begin by introducing our distinguished panel, starting with the Honorable Kimberly Davis Bocelli. General Magistrate Bocelli was appointed by Chief Judge McHugh in 2015. She presides over civil matters such as general civil, guardianship, probate, and mental health proceedings. She routinely presides over hearings on petitions for involuntary inpatient as well as involuntary outpatient that are brought before her pursuant to the Florida Mental Health Act. Next, I'd like to introduce Assistant State Attorney Amy Kaczynski. Amy Kaczynski is a graduate of the University of Illinois and also the Southern Illinois University School of Law. She has been employed as an Assistant State Attorney for the 20th Judicial Circuit since 2002. During that time, she's been significantly involved in treatment courts, such as juvenile drug court, mental health court, and veterans court. She's also been involved in representing the state in Baker Act hearings since 2019. Next, I'll introduce Veronica Batt. Veronica attended the college at the University of Malta in Rome, Italy, and majored in law. Ms. Batt moved to the United States in 2009 and attended Ave Maria School of Law and graduated in 2012. She's been an assistant public defender for over 7 years and has been doing exclusively Baker Acts on behalf of the Public Defender's Office here in Lee County. She lives in Lee County with her husband and 3 children. Next, I'll introduce Leanne Martson. Ms. Martson holds a Bachelor's of Arts in Psychology from the University of Miami and a Master's in Social Work from the University of Central Florida. She joined Park Royal Hospital in October 2013. She has experience in adolescent, geriatric, chronically mentally ill, and chemically dependent populations. She oversees all clinical programs, including outpatient and inpatient clinical services at Park Royal. She serves on the executive board of NAMI, Lee, Charlotte, and Hendry County. She's passionate about ending the stigma of mental illness and advocating for those who feel invisible. We're very excited to have this great group of panelists to discuss the Baker Act here in Florida, as well as locally in Lee County. According to the National Institute of Mental Health, nearly 1 in 5 adults lives with a mental illness. Now more than ever, mental health knowledge and advocacy is at the forefront of our minds as it touches all of our lives. With that said, let's jump into our discussion today about the Baker Act. I'd like to start with Magistrate Bocelli. Magistrate Bocelli, can you tell us what is the Baker Act and what is the purpose of the Baker Act? And turn this on.
All right, thank you. Well, the official name of what we call the Baker Act is the Florida Mental Health Act, and it's contained within Chapter 394 of the Florida statutes. It was passed to allow for the creation of mental health programs designed to, quote, reduce the occurrence, severity, duration, and disabling aspects of mental, emotional, and behavioral disorders. Basically, it lays the groundwork for voluntary and involuntary emergency admissions of those suffering with mental illnesses, and it provides rules and regulations surrounding the commitment of qualified patients. It provides the responsibilities of law enforcement and healthcare professionals and outlines the rights of clients when they are admitted to a mental health facility. It provides checks and balances for community safety on one hand and individual liberty on the other. And I believe all 50 states have some version of Baker Act that is similar to what we have here in Florida.
Thank you. The next question is for Assistant State Attorney Amy Kaczynski. When the community at large often hears of the term "an individual was Baker acted," can you tell us what does that mean and what are they referring to?
So what that means is that the person has been taken to a receiving facility for examination, and what the examination entails is to determine whether or not the person has a mental illness, and because of that mental illness, the person either refuses treatment or is unable to recognize that they need treatment. And if they do need treatment, what they're also looking for is, if left alone, would the person be able to survive, or would they suffer from such neglect that they are at risk of substantial harm, or whether or not they would be likely to inflict. I'm getting a wave. Can you guys not hear me? Is that better? Okay. Or whether or not there's a substantial likelihood that they will inflict serious bodily harm on themselves or someone else. So again, that just means the examination.
So when the community at large hears that there is an individual who has been Baker acted, that's referred to the involuntary examination statute, which is 394-463. And like Amy said, it's just when somebody is brought to a receiving facility to make sure to undergo an assessment. So Veronica, can you describe the only three ways that an individual can get to a receiving facility, and sort of explain what a receiving facility is?
Sure. So there's 3 ways that someone can be taken to a receiving facility. The first way is through a court's ex parte order. So if the court finds that the person meets the criteria for involuntary examination, it issues an order, and then a law enforcement officer typically picks up the person and takes them to the nearest receiving facility. The second way is if a law enforcement officer believes that the person might meet the Baker Act criteria, they take them to the nearest receiving facility. And the third way is a professional, either a psychiatrist, psychologist, can execute a certificate saying that they believe that the person meets the Baker Act criteria, and then they're also taken to the nearest receiving facility.
Thank you. So those are the only 3 ways that an individual can be taken to a receiving facility. Veronica, what if somebody is determined to meet the Baker Act criteria, but they have an emergency medical condition? Does the Baker Act statutes describe what happens in those circumstances and what the obligation is of the hospital and the receiving facilities at that time?
Sure. So if someone experiences what's called an emergency medical condition, typically they're taken to a medical hospital to be evaluated. Once the physician finds that the emergency medical condition has ceased, they have to take the person within, one of 2 things has to happen within 12 hours. Either the person is released if the physician in the medical facility documents that they don't meet the Baker Act criteria, or they are, excuse me, they are taken to the nearest receiving facility to be examined for involuntary examination, and that has to occur within 12 hours. And the facility has to be notified within 2 hours of the emergency medical condition being stabilized.
Thank you. Can everybody hear in the back? Yes? Okay. Now, I'm going to turn my next question to Amy. Who qualifies for the Baker Act in Florida, and what happens if somebody is brought to the receiving facility under the involuntary examination statute? How long are they going to be there, and what happens when the time is up?
So in theory, anybody who's physically present within the state of Florida that is presenting with the appropriate symptoms could be brought to the Baker Act receiving facility. When they are brought to the facility has 72 hours to perform the examination. They actually have to be seen by 2 different individuals during that examination period. If they do meet the criteria for involuntary inpatient treatment, that the facility must file a petition. If they do not meet the legal criteria for involuntary, they must either be discharged or transition to voluntary status.
Thank you. Now, we're going to discuss the 2 different types of involuntary proceedings that can occur in Florida. But before we talk about that, we're going to turn to the roles and the responsibilities of each party at these proceedings. So, Amy, since you have the microphone, what is the role of the state attorney's office in an involuntary petition hearing?
So the state attorney's office is appointed as a real party of interest. We do not represent the facility. Obviously, our goal would be to protect public safety. So that's why I believe that we're the real party in interest.
Magistrate Bocelli, what is the role of the court during the involuntary petition proceedings?
Well, I preside over, myself and the other magistrates are usually the ones who preside over these hearings by appointment of the chief judge. And our responsibilities are to conduct a fair proceeding, to listen to the evidence, to make a decision based upon the evidence in light of the criteria that applies. It is a clear and convincing evidence standard, so it's a pretty high burden to get over. And the rules of evidence do apply, so you have to apply all those. And I know the state can sometimes have difficulty with getting all the witnesses that they need to prove the things that the doctor was told. But that's what we do from the court's perspective.
Thank you. And Leanne, can you talk about what the role of the hospital is during these proceedings?
Sure. So once the patient enters the hospital, our role is to get that petition filed timely. So we require 1 opinion by a psychiatrist and the second within 72 hours. So our role would be providing that evidence that the patient meets that criteria.
Thank you. And Veronica, what is the role of the public defender's office at the involuntary petition proceedings?
So basically, I do what my client wants me to do, in essence. There's a case that's directly on point that talks about the role of the public defender. I am not a neutral party charged with determining the best interest of my client or determining the best interest of society. My job is to be an impartial advocate, a very aggressive advocate for my client and for what they want me to do with regards to their personal liberty.
Sure.
I just wanted to also point out that the patients do have the right to represent themselves and assert the right to represent themselves. And I've heard a number of hearings, FREDA inquiries, and having to decide that where the PD, they don't want their public defender representing them and they want to represent themselves. So we go through the colloquy and I make a decision. But it's not all the time, but I've had a number of them in the last 5 years. So just wanted to point that out.
And Magistrate Bocelli, that reminds me, you discussed the rules of evidence apply. Which rules of evidence apply at a Baker Act proceeding?
All of them.
Is it the rules of civil procedure?
Oh, for procedural rules, it is the rules of civil procedure. It is a civil commitment proceeding, but due process still attaches. So clearly constitutional rights as well as rules of evidence under Chapter 90 and civil rules. And my appointment, as I understand it, is both through the statute and through Rule 1.490.
Leanne and Veronica, can you both discuss what is an involuntary inpatient petition and what really needs to be included in the order for the facility to file, and what, Veronica, are you looking for as an attorney when you're representing an individual who's being considered for an involuntary inpatient placement?
So the petition that we file has, the first step of it is to get express and informed consent. So we figure out if the patient meets the criteria for the Baker Act, and if they are a competent Baker Act or if they are considered an incompetent Baker Act. When someone is considered an incompetent Baker Act, we also file a petition for guardian advocate. In that petition is the first and second opinions.
And Veronica, what are you looking for as an attorney that's going into the facility to represent somebody as far as involuntary inpatient placement is concerned?
So under the statute, what I'm looking for and what the court is going to be looking for, I would assume, is clear and convincing evidence that either my client or that my client has a mental illness, and as a result of that mental illness has either refused voluntary treatment or cannot determine whether they need that involuntary treatment. And whether they are able to survive alone or with the help of willing family and friends. And if they're not, or in addition, if there's some sort of neglect that has occurred recently that will lead to substantial harm to themselves, or and then also whether they are a risk of serious bodily harm to themselves or others, as evidenced by their recent behavior. And lastly, that all the less restrictive treatment alternatives have been exhausted and been adjudged to be unavailable.
Thank you. Magistrate Pacelli, what happens if the court grants the involuntary inpatient petition, and what is the length of time of that order? And if you also want to discuss what happens if they're denied.
One thing to mention before that is the patients are entitled to up to 4 weeks of continuances, so a lot of times the hearings can be pushed out if the patient wants a continuance. Now, they can have the right to have their hearing within the 5 business days from the filing of the petition under the statute. But assuming they want their hearing and the facility proceed, or the state decides to prosecute it, and the court finds that all of the criteria is met based upon clear and convincing evidence, then the court would recommend admitting the patient for a period of up to 6 months at either a receiving or treatment facility. There is additional findings that have to be made if you want to place them at the state hospital. There has to be a transfer evaluation. You have to have testimony from that additional witness. So that would be, in either event, it's up to 6 months. After that, continuances are considered by administrative law judges under administrative hearings. And then so the flip side is if the court finds that there is not clear and convincing evidence regarding each of the criteria, then the petition is denied, then the patient is to be discharged forthwith, is what I say. That usually is treated as the same day, by the end of the day, preferably. And the facility has to get the patient ready to be discharged back into the community. But I apply the law and the evidence as to the facts presented to me, and sometimes they're denied too. And unfortunately, sometimes the family members are not happy that happens because of the person having a mental illness, but that's only one of 4 criteria. So we have to make sure that all 4 are met.
And Magistrate Pacelli, we've been talking about involuntary inpatient petitions, but are there different involuntary petitions that come before you, and what are they?
Well, there are also, in addition to the inpatient, there's outpatient petitions. Those are where they're seeking to be ordered to outpatient treatment. Those are up to 90 days. If those are granted, they may be continued for periods of 90 days to 6 months. After that, they usually take, from what I understand, about a year to get to the conclusion on average. But there's also one thing we didn't talk about yet was people can come in voluntarily and then be transferred to involuntary status and vice versa. So if a patient comes in voluntary and they want to leave, but the physician or the psychiatrist doesn't believe that they should because they meet criteria, then the Baker Act, the commitment proceeding would start. I think it's 2 days to file the petition from voluntary status. And then if the patient improves while awaiting their hearing on the involuntary inpatient or outpatient, then the patient can be transferred to voluntary status at any time that I believe that the psychiatrist deem it appropriate.
Thank you. Leanne, can you describe what voluntary, when somebody comes in voluntarily under the Mental Health Act, it's Magistrate Pacelli touched on it a little bit just now, so about going voluntary to involuntary, but are you familiar with the process of when someone comes in voluntarily and what that would look like for them?
Sure. So the difference between involuntary and voluntary is voluntary person can make well-informed decisions and can have treatment options, and they can make the best decisions regarding that. Involuntary, you're saying that either they've refused to make treatment decisions or they are just unable to make treatment decisions.
So any person can walk into Park Royal and say what to get admitted voluntarily? What would we be looking at from the hospital's point of view?
There's various type of reasons and conditions. Mainly when we're looking at the inpatient side, we are looking at people with suicidal ideation, homicidal ideation, people who just are unable to care for themselves, and in that way they are neglected. So that would be the main inpatient criteria. But we get depression, we get bipolar disorder, and that of course manifests in many different ways.
Thank you. Now, we talked about involuntary inpatient placement, and now we're going to turn to involuntary outpatient placement. Amy, can you go through what the criteria is for involuntary outpatient placement and what that looks like?
So that's something that we actually recently started doing here in Lee County. Centerstone is our treatment provider for that, although the Big Rec receiving facility is still required to file the actual petition. And the criteria for that are the person has to be 18 years of age or older, they have to have a mental illness, they have to be unlikely to survive safely in the community without supervision, they have to have a history of lack of compliance with treatment for mental illness, and twice within the last 36 months, they either have to have been involuntarily admitted to a Big Rec receiving facility, or they had to have engaged in one or more acts of serious violent behavior towards themselves or someone else.
Magistrate Pacelli, how have we had a lot of these so far, the involuntary outpatient, since it's fairly new, or how is it looking?
I think they started that in December of 2020, and I preside once every 3 to 4 weeks, depending on the rotation and how many magistrates we have at any given time. So I think we've had, I wouldn't want to quote a number, 4, I'm hearing 4. I just recently today had my first continuance of one, so that one was at least 90 days ago. For it to be up for continuance at this point. So they're not as frequent as the inpatient involuntary ones, but they're, I think, picking up speed to some degree.
And Veronica, you've represented individuals who are receiving the involuntary outpatient services. Can you describe to us what that looks like and why there's a need for it here in our community?
Sure. So most of my clients who have qualified for the outpatient services have really desperately wanted treatment. So it just appears that in our community there's a huge void as far as voluntary mental health treatment. So it has kind of been diverted to the involuntary outpatient program, but they've all been very eager to participate in treatment. So, yeah.
Okay. Now, we've discussed a little bit about receiving facilities, and then we've heard about the state hospital. So there are 2 receiving facilities here in Lee County. There's Park Royal Hospital as well as Salus Care. Leanne, if you can talk about Park Royal Hospital and just give us a general overview of Park Royal. And I believe Park Royal is both a receiving and a treatment facility as well. It's designated as both. So if you could just talk about it.
So for the purpose of the Baker Act, we are designated as a receiving facility. As Jessica mentioned, we have various units inpatient, which include also the ECT suite and co-occurring, which is mental health and substance abuse combined, geriatric unit, and the acute unit. which would mean that somebody is hearing things or seeing things and are really struggling with that and may become aggressive due to that.
Thank you. Veronica, there's not a representative here from Salus Care, but based on your experience going there, can you tell us a little bit about what Salus Care offers as far as the Baker Act is concerned and what you've seen?
Sure. So Salus Care is more of like a public Baker Act receiving facility, more for my clients that don't have insurance, for instance. They do offer outpatient services voluntarily. But mostly the hearings that I have there, they have a transfer evaluation to the state hospital. So if a person is committed under the Baker Act, then they are transferred to a state hospital thereafter.
Now,
Oh, and they also have the minor unit for children as well.
and is the public defender's office appointed to juveniles if they're Baker Acted? And you want to give a little summary of that?
Sure, yes. We are appointed to juveniles. In my 3 years doing Baker Acts, I've only been appointed one time. So the thought is that a lot of them are signed in voluntarily by the parents, but I don't get to see them very often.
Which is surprising because I'm sure everybody here who does mental health has heard that our juvenile Baker Acts are up severely in Florida. Can you tell us a little bit about when a person is being held involuntarily, Veronica, what their options are if they believe they're being held illegally, and if the public defender's office assists, or if a defense attorney can assist in that way?
Sure. So if somebody believes that they're being held illegally or some kind of a right of theirs is being violated, they can ask someone at the receiving facility to file a petition for a writ of habeas corpus on their behalf. A lot of times I will do that if I see them at the facility and they get my attention and tell me that they believe that they're being held illegally. I will go ahead and meet with them and fill out a petition for a writ of habeas corpus.
And how are those heard, the writs?
Typically within the writ, I request that it be referred to the magistrate for a hearing during the regular Baker Act proceedings. So that's twice a week is when they would be heard during the Baker Act docket.
Now, are there specific time limits for the filings of the Baker Acts and when the hearings are heard routinely?
Yes, so the 72-hour period is the initial observation period, so the petition has to be filed within 72 hours of the person entering the receiving facility. If the 72-hour mark falls, for instance, on a Saturday, then they would have until the very next business day to file the petition. And what was the second part of your question?
I don't remember.
The
timing of the hearing.
And the hearing has to be held within 5 days of the filing of the petition. So the way that it's timed, that we have court every Tuesday and every Friday, that pretty much gets all of working days.
Now, what are hearings held during holidays? Or how does that work?
Sure.
So it's working days under the statute, so that does not include Saturdays, Sundays, or any legal holidays. And legal holidays is either the court being closed or the clerk being closed. So we have had a couple holidays where one or the other of us is closed, but it's still considered a holiday. And then we have never had to create a new day on top of the regular Tuesday and Friday because you don't count that intervening holiday. But the court usually will send out a confirming email saying, like, this is holiday, we're not having court that day, we'll just pick up the next Tuesday or Friday. I did want to add one thing on the habeas corpus proceedings. So there's usually two categories of habeas corpus, and they're sent to the judge reviews the petition first and decides whether there should be an order for a hearing conducted. And then they routinely do the orders of referral so that the magistrates can hear it at the regular docket. And so the two categories, as I understand it, are either some procedural issue in the timing of things, like the petition wasn't filed timely or the hearing wasn't conducted timely, something like that. Or alternatively, the statute does say that if at any time the patient no longer meets the Baker Act criteria, they shall be discharged. So the facility has an affirmative duty to discharge a patient if they don't meet the criteria. So I have seen petitions based upon the fact that I don't meet the criteria. I don't have a mental illness. I should be released to my parents, which implies a less restrictive alternative. So those are the two general categories that could support the issuance of a habeas corpus order to show cause as to why they shouldn't be discharged.
No, that's good. Thank you. Leanne, I want to point this next question to you. Over the years, we've observed that there seems to be a fundamental difference between a clinician's approach to a Baker Act versus a legal position towards a Baker Act. And I was wondering if we could maybe get your perspective from a clinician of when a clinician feels that a Baker Act needs to be granted and sort of how that plays out at the hospital.
Sure. So, and clinicians vary. You can be a social worker, you can be a licensed mental health counselor, and it's basically your clinical opinion on choosing if the patient is suffering from neglect, without care, that they can cause serious bodily harm to themselves. So the legal definition or how they see that sometimes does differ from how a clinical social worker would see that.
And Veronica, can you maybe give us from a legal perspective just your observations of this difference through your experience in different hospitals?
Sure. So I think the case law is very important kind of in specifying within those two criteria, the neglect criteria or the serious bodily harm criteria, what both of those criteria are. So for instance, a common issue is failure to take mental health medication, and that has been held, that's not enough to commit someone under the Baker Act. There's several cases directly on point. There's the Singletary case, the Lishka case. Also, serious bodily harm is not emotional harm. So just because you're scaring someone, that won't meet the 2B criteria. It has to be actual physical serious bodily harm, and that's defined by the case law as any harm that necessitates medical attention. So just little common pitfalls that when you read the statute on its face, you don't realize like what a high burden this truly is to meet the criteria.
And can you give some examples of the misconceptions of neglect that you've seen
Sure.
and ways that you've litigated these cases and prevailed in getting them out of the receiving facility?
Sure. So the biggest issue is speculation, right? So as far as neglect, this person surely can't eat by themselves or procure food for themselves. So, one of the things that we're looking at is not speculation. So did the person come into the hospital malnourished or dehydrated? That would be actual evidence that is something that's occurring versus speculating that in the future this person won't be able to eat or take care of themselves. Likewise, for serious bodily harm, has this person actually threatened, attempted, or actually caused someone serious bodily harm or themselves, and not whether, well, the person's not taking their medication, so they're going to cause themselves serious bodily harm. So it's important to not speculate, look at specific instances of these things that have occurred versus just speculating in the future that they might occur due to someone's deteriorating mental health condition.
And in your experience, do all psychotic people meet the Baker Act criteria, or can there be individuals who suffer from a profound mental illness but are going to be released, and why?
Not at all. So there are plenty of people who are psychotic that do not meet the Baker Act criteria at all. In fact, I would say most of the ones that I've met with probably did not at the time that I met with them. So again, it's not speculating based on the observations of them maybe not taking their medications or possibly hallucinating or hearing voices, but are they actually threatening or attempting or causing themselves or someone else serious bodily harm? So we can't predict the future without having some kind of an indication in the present that it's going to happen.
And what about property damage? I know throughout the United States, many states have different types of standards, but here in Florida, if somebody harms the property, is that a reason, like in a psychotic state, is that a reason to Baker Act somebody?
No, it is not. I know certain states like Wisconsin have that written into their version of the Baker Act law, but destruction of property is not, does not equal commitment for under the Baker Act.
Thank you. So Leanne, we're going to turn to you and we're going to talk about discharging. what does the hospital do to prepare to discharge someone if they didn't meet the Baker Act criteria or if they stabilized? What is a normal course of business for discharge planning?
There are a few important aspects. We always try to get some kind of contact with the family to see the view of how are they feeling about the patient discharging, but mostly to make sure that they can confirm what the patient is telling us about their discharge plan. Because sometimes a patient can say, I have a home, and they really don't. Or they can say they're going to this friend's home, and it's really a made-up friend. It's not a real person. So really ensuring that discharge plan is safe. That is our most important responsibility. So we do that. We do crisis safety plans so that the patient can prepare to re-enter the community. And of course, we try to make sure however they get to their discharge place, which could be another facility, which could be their home, we want to ensure that they get there safely and that they have an appointment within 7 days in the community with a psychiatrist or a therapist.
That's great. Yeah.
Doesn't that also include less restrictive alternatives and making arrangements?
They can't hear you. Wanna grab the mic?
Doesn't your discharge planning also include making arrangements for less restrictive alternatives in the event the court finds there are less restrictive alternatives, like the FACT team, which I don't know if somebody else wants to talk about what that exactly means, but those types of outpatient services that might be appropriate?
So, Veronica, do you want to give a summary? Do you want to talk about the FACT team?
I can talk about the FACT team. It stands for, I think it stands for Florida Assertive Care Team, and it's been described to me as kind of like a mental hospital without walls. It's basically a team of people that provide all kinds of wraparound services. They will go to the person's house, they will bring them medication, they will help with housing, and all kinds of different wraparound services that they offer, and it's really valued especially in our community, and even on mental health court. We have a lot of people on the FACT team, so it's a great team for people who qualify for it.
And Veronica, can you talk about the reason why involuntary outpatient services are actually wanted by our clients because of the deficit of the FACT team availability?
Sure, because it's also like a mental health facility without walls in certain aspects. So they go to them with their medication. I've had clients in the furthest edge of Lee County, and they drive out there and bring them their medication. They drive out to them if they're in crisis. I've had this happen recently. And they provide those services that unfortunately otherwise my clients would not be able to access. So it's just a big void within the community in services that we wish that we had without having to commit people involuntarily to them. And most of my clients really want these services, and it's unfortunate that they have to seek them involuntarily versus being able to just get them voluntarily in the community.
And this question, because we're getting close to our time, so this will be for everybody on the panel. Can you describe what the hardest part is of handling a Baker Act within the roles that you have? Or that you are? You can start.
Okay. So for me, it's probably people understanding my role. I have to do what my client wants me to do. I am not an impartial person. I don't do the interests of society. When somebody is in their most vulnerable state and they believe that no one else is there to listen to them and do what they want, I'm there to listen to them and do what they want me to do. So I think that's the biggest, the hardest thing in my job is people understanding my role.
For me, it would be the discharge planning and making sure that they have a safe place to go. We have a very big problem in Lee County with homeless and the lack of shelters. And a lot of times the patients at Park Royal, they may even be banned from those shelters because of their behaviors while there. So discharge planning is huge, and also the family wanting the patient to be in the hospital, but us, of course, having to honor the patient's right that they are stable and they can leave the hospital.
Thank you. Me?
I would say, from my perspective, I have two equally hard ones. The statute requires me, as the person proving this petition, to provide proof that the person has exhibited these dangerous and threatening behaviors. And I can't just depend on anything speculative. I can't depend on what the doctor thinks should happen. I have to prove, behaviors, and a lot of those behaviors happen before the person gets to the hospital, and I don't get any access to anything other than the actual Baker Act petition. So I don't know why the person was brought to the hospital. I don't know who was involved in that, and I have to be able to prove that. And I have to make sure that I have witnesses, and I don't get any discovery, so I have no idea how to prove it unless somehow the hospital clinician or someone at the hospital can tell me, oh, by the way, there's this, or the patient admits it. And so it's very, very hard for me to win these when I get no discovery. Well, the other one was the statute itself requiring me to prove behaviors based on either a threat of serious bodily injury or an action exhibiting serious bodily injury. And that's really hard because I kind of think we should include maybe some property damage, because a lot of families, I think, are scared when their loved one starts, destroying property, and they're really worried for them, and they think that the Baker Act is going to be this magic solution that's going to result in their loved one getting treatment, and that's not necessarily the case, and certainly not based just on the Baker Act. So.
For me, as I said before, my job is to apply the facts to the law, and it's a high standard, as already noted. It can be challenging when I see a patient who clearly would benefit from treatment, but the case law is very clear that the benefit of treatment is not enough. You have to meet all 4 criteria. You have to be manifestly incapable of surviving alone, or have recently caused, threatened, or attempted serious bodily harm. And a lot of times that's just, the evidence is not there, and that ties into Ms. Kaczynski's difficulties. And I have to discharge them, and they're discharged within a day, and the facility doesn't always have a lot of time to make discharge arrangements, but that's what the statute says, and that's what I'm required to do. And, sometimes I wonder, I hope I don't see this name in the paper tomorrow or next week because I had to discharge them because they don't meet the criteria, but that's the law, and that's what I have to do.
Well, we appreciate all of your input. I want to thank the panelists for their specialized knowledge and time today. I also want to thank the audience for your time and attention today. The Baker Act is really a term that we use to describe the involuntary examination period. It's really used for people who are a danger to themselves or others, or they're neglecting themselves so much that there's substantial bodily harm. And as we heard, there's frustrations on all sides of the different type or the roles in the Baker Act. We've heard about the discharge planning if an individual doesn't meet the criteria. We've heard that if they do meet the criteria, they're involuntarily ordered to comply with treatment, whether that's inpatient or outpatient. One thing I just want to leave everybody with is we heard briefly about the FACT team services that we have, and that's basically services in the community. They're not involuntary, they're voluntary services. They're a hospital without walls. They will bring medicine to people, and we just don't have enough funding for them locally. And so the petitions are being filed for involuntary outpatient, and clients are actually wanting involuntary outpatient services, which is it shouldn't be. We're very lucky, though, as a community, that Centerstone has received a SAMHSA grant as of December 2020, and they have about $5 million to provide involuntary outpatient services in our community. And so hopefully, our community will come together, and we will be able to continue to provide outpatient mental health services and provide the resources that the hospital needs for housing to make a difference. I want to thank everybody for their time. We're out of time, but I'm sure that the panelists, if you have any questions, we would be happy to take them if you want to stay. Other than that, we're done. Any questions? Yes. I'm gonna repeat it. What the question is, what is the percentage of individuals who are detained for the involuntary examination period and then released from there or committed from there?
In terms of Park Royal Hospital, our facility, we actually have a very large population of voluntary patients. There have been times in past years where it was, 70% Baker Act or something of that nature. But we have a pretty high population of voluntary patients.
So the question is, when an individual is brought in for the 72 hours, are they released before the 72 hours? Do you know what the percentage is, or approximately, do a lot of them get released before the 72 hours? Do they stay for the 72 hours? And if they stay at that 72-hour mark and the facility files the petition, how many of them are actually required to stay, or are they denied? Do you have those statistics?
No, I have a CFO who handles those percentages. It's all about the clinical criteria. If they do not meet the Baker Act criteria, then we don't file the petition.
And Veronica, you could probably talk about how many you take to a hearing from a defense attorney's perspective and how many you win.
Sure. So, I set several cases, each court date for hearing. Then at that point, there's preparation that goes into it, seeing, the legal criteria, looking at the discovery and things of that nature. How many actually go to a hearing? I don't really know offhand. I would say, though, as far as success rate at the hearings, it's a very high burden to prove. So I would say, as a defense attorney, it's I don't know. I don't know how to put it.
I don't keep statistics on that, and I'm only one of several people who hear them, but I'll say that because the patients have the right to continue the hearing, a lot of times they're getting treatment while their hearings are being continued, and a lot of times they improve over that time, such that they're discharged because they no longer meet the criteria, or Ms. Batt will request a hearing, the state will meet with or talk to the doctor, because at least one of the doctors has to testify. And if, as I understand it, Ms. Kaczynski exercises prosecutorial discretion, and that sometimes she decides there is not enough evidence here for me to prosecute this. So sometimes hearings don't happen because they're not prosecuted. And then when they do, actually, there's a hearing requested, the state's prosecuting it, and I personally hear it, I would say it's probably 50-50, because usually it's a really good case if it's being brought to that point. I want to commend the state attorney's office and the public defender's office for providing, we now have designated attorneys for each docket, so they are familiar with the process, they're familiar with the standard, and it's really a lot more efficient than it has been maybe in other times, that they work together well, and we are only hearing cases that have a really good faith basis to be heard. So I would say maybe 50-50 of those that actually get heard are granted. 72 hours, and then 5 working days. So you're gonna have to look at the calendar to figure that out, and it depends on if it's voluntary. If it was a voluntary that turned involuntary, it's 2 days from when they turn involuntary, plus the 5 working days. And then, well, it could be involuntary. It's not 72 hours if it's voluntary turned involuntary, you don't use 72 hours. It's 2 days from the transfer from voluntary to involuntary. It's slightly different.
But at least 8 days. working days. So, and if it's Christmas and there's, to Christmas Eve and Christmas Day, it could be 10 days before you have a hearing, but usually it's within 8 days.
There's a lot of math that goes into this.
And they also have the right to retain private counsel if you don't want to have the public defender representing you. It can be hard when they're in a facility, but they can do that.
So I think we're out of time, but we'll stay up here while you guys eat. And if you guys want to come up, we can answer. But I think we're going to have to wrap it up totally for everybody.
Getting off the script. Thank you guys very much for everything, all the insightful information today. And if anybody has not signed up for the Downtown Dash and wants to sign up, I believe signups are from 4:30 to 6. Thank you again to Park Royal, our lunch sponsor. And yeah, definitely. Chapeau. And we have the golf tournament, the foundation golf tournament. It's not our golf tournament anymore. We gave it to the foundation a few years ago. May, what is it, 15th? 16th? I just asked you. 15th, there you go. 15th, May 15th. And our next luncheon is June, come on guys. I believe it's June 16th. Don't quote me on that, but we'll send out the information for it. It's going to be our annual diversity and inclusion luncheon, so we're really excited for the topic and panelists, which will be announced very soon. So everyone have a good weekend.